Well, today I'll be delivering you the third video session on National Compulsory Tribunal, and I hope that you had well received the first and second video. In the third video, which I am going to speak about now, is very important and very crucial provision in the Companies Act 2013 under the ambit of National Compulsory Tribunal is coming. And before I go into the detailing of the section, I like to introduce you the beautiful concept called what is a class action suit. See, this terminology of class action suit is very famous in US laws, US civil and criminal laws. But in India, it is the new concept which is now introduced through the Companies Act 2013, which is simple. When a group of individuals have the same cause of action or they have been affected by the same company, they can, in respect of, without going for an individual suit, they can file a petition against the company or the directors in a combined way, that is called class action suit, so that a group of persons problems can be clearly been represented by a single person and filed before the tribunal. So this is going to be a huge area where you all you will appreciate the deposit holders or the shareholders in common. If for example, if a company has 60 deposit shareholders, you cannot expect that each and every individual going to a civil court and having petitions, incurring the legal cost. Rather than all the 60 persons can now combinedly file a group petition before the tribunal. Maybe a person can represent them. This concept is called class action suit. This class action suit will clearly pave way for better corporate governance, so that the deposit holders and members have now a good say in the law. Now, what happens in Companies Act is we have a separate section for this, section 245, which empowers the members of the company, the deposit holders of the company, to file a class action suit against the company, against the directors who acted fraudulently. So this is the whole concept. Now the concept is for which things they can move to the tribunal. There is a list of the cases where they can go, the offences, which has been clearly stated in 245. I'll give some examples. One is when the company or the directors is acting ultra vires of the memorandum and or articles of association. 1. 2. When they act in contrary to the provisions of memorandum or articles. And the very interesting point is, even when the company or the directors are acting violative of any provisions of Companies Act 2013 or any other law for the time being force, also the shareholders or the members and the deposit holders can move against the company and the errant directors. So this means a clear case of legislative compliance insurance is being introduced in the class action suit provision 245. Now I told what are the areas by which where you can file a petition. Now the question is, against whom this petition can be filed. Petition can be filed against the company, of course, to the errant or fraudulent directors, and the third one is very important, to the auditors or the audit firm. In that case, the audit firm and the partners who are involved in the misstatement in their audit report is the persons we are talking about. So against audit firm or the partners who are clearly involved in the misstatement in their audit report. So that means the whole concept is very clear that hereafter, especially when the notification of section after the notification of section 245, the things are going to be very serious. The members and the deposit holders, apart from the other remedies they have, now they can move collectively. A group of commonly cost members or the deposit holders can now rather than going individually, they can be a group, and collectively a single person or a single deposit holder can move against the company who had been or the directors who are not doing the correct thing, the fraudulence. This is a beautiful remedy which have. There are other provisions which detailing like how many members can move, how many deposits can move, what was the order. One thing I like to make it very clear before I conclude this video is that before accepting an application or entertaining an application, the National Compulsory Tribunal will see whether the deposit holders or members are acting in good faith. This section should not be misused. So whenever the members collectively and the deposit holders collectively move in a good faith, this 245 can be used, so that hereafter you need not want to say that there are many members who are affected, but who will go first or who can go. Now we can combine the petition. All the members who are affected by the same cause of action by the same company or against the same company or the deposit holders can now collectively move against the company under this forum, and this authority is again the National Competition Tribunal. Again, I like to highlight, NCLT will have such a very good a legislative control over the companies which are going and doing things wrong. So 245 deals with class actions is going to be a huge tool for the members and the deposit holders to ensure that their rights are perfectly upheld, and the company is being complying in a right spirit. So the other things which I will come in my next video. I hope that you will enjoy this video also. Thank you.